Tomorrow I'm going to, be on call at CNN because we may hear whether they grant cert on the Defense of Marriage Act cases and the Prop 8 case.
Or we'll have another day of disappointment.
Right, yes.
Like, what time are they going to say?
Yes, I know.
Do we think they're going to accept one of the cases?
Well, I'm sure
Kenji,
we all have all these views.
Kenji, what do you think?
So I absolutely think they're going to take one of the DOMA cases. So again, as an explainer.
Yes, please.
The Defense of Marriage Act is a 1996 federal statute that defines marriage for all federal purposes as being between one man and one woman. So even if you live in a state that allows same-sex marriage, that means you have a split marriage. So to make this really concrete, one of the plaintiffs in these cases, Edie Windsor, was with her partner for 40 years, married her in Canada, that was recognized in New York. When her partner passed away, she was next of kin in the eyes of New York State, but she was a legal stranger in the eyes of the federal government, so therefore got hit with $363,000 of federal estate tax, which she would not have been hit with had she been recognized as married for both federal and state purposes. So one of these cases, possibly the Windsor case, is going to be granted because it's not a 100% rule, but it's a 99.9% rule that if a federal appellate court strikes down a congressional statute, the Supreme Court will grant cert in that case. So one of those 8 petitions, or actually 8, DOMA cases out there, is going to be granted. I think the real nail-biter is going to be whether or not they grant cert in the Perry case, which is a state definition of marriage. The thing about the DOMA case that makes it a relatively easy case for the court, because I think they're going to do the right thing and strike down the Defense of Marriage Act, as all the lower courts have done, is that it's a kind of mashup of Justice Kennedy's most favorite things. So it's like states' rights, and gay rights. And he loves states' rights, and he loves gay rights. And so this is like, you might as well just get Julie Andrews to go in and sing the oral argument to the court.
And this was, of course, very deliberate on the part of the gay rights litigators who are bringing these cases. They're perfectly teed up these cases to be an incremental step. Right?
Exactly. And so you're asking the court to take a very, very small bite because, as Emily is saying, the federal government has traditionally deferred to the states with respect to family law generally, right, and marriage in particular. So this would simply, by overruling DOMA, all they would be doing is returning Congress to the posture of following whatever the state's definition of marriage was. Whereas in the Perry case, which is a California Prop 8 case, you have this initiative that says marriage is only between one man and one woman in California, and if the Supreme Court strikes that down, then that could possibly have ripple effects. So I think one of the things in other states, and one of the things that I think many people have been inattentive to, is that there are actually lots of breakpoints. So I think people usually think, okay, it's either going to be 0 or 50. And I think both 0 and 50 are quite unlikely. I think it's either going to be a denial of cert, in which case marriage will return, but only to California, because the Ninth Circuit wrote a very narrow California-specific
kind of right away
opinion.
That's going to happen, right?
Yeah, exactly.
They're getting ready to have ceremonies tomorrow.
Yeah.
That seems, I don't get
right?
that. Don't they have to do some kind of lifting of the Ninth Circuit?
There has to be a mandate.
Okay.
Yeah,
I just want to make sure there was some step. I guess,
the
but Judge
clerk
Reinhart
in San Francisco is ready to give licenses tomorrow.
Yeah, and it's actually asked the court for 24 hours notice so that they can actually get ready. And of course, the court has not.
We stay tuned.
I just think
that's interesting.
This is where the court, as a political institution, may well come to the fore. As he has done now several times, Kenji really defined the issues very well. But another way of looking at it is DOMA only applies in states that already have same-sex marriage.
That's correct.
So you're not going to be imposing anything on Alabama if you strike down DOMA.
That's the incrementalism.
Right, that's it. Prop 8 is a much more incendiary possibility politically.
Right.
Because, if they strike down DOMA, it just doesn't matter outside the states that already have same-sex marriage. And with the exception of Iowa, I think all the states that have same-sex marriages, it's pretty uncontroversial the fact that they have it at this point.
Right.
Prop 8's a very much more toxic potential there, because there you're really talking about saying you're really looking at it as the Loving versus Virginia of same-sex marriage, which Loving versus Virginia in 1967 said, finally, states cannot ban racial intermarriage. Long overdue, but by 67, But the question is, even if there are justices on that court, as I suspect there are, who think bans on same-sex marriage are just as unconstitutional as bans on racial intermarriage, they're thinking, you know, let's hold off on this for a while.
Well, and the argument for holding off is that the polls are shifting in so dramatically and quickly in a progressive direction, and if you just give the country a little time to get used to this idea because it's going well, and the states that have it will be there. And this is the Obama argument you referred to earlier, Nan, about where does social change come from, where does it take root in the most productive way.
But here's the thing. So I want to say something for and against this agreement that's been reached. So for it, I would say you're absolutely right. There was, at the time of Loving versus Virginia, only 16 states had retained bans on interracial marriage. Currently, 41 states have restrictions on same-sex marriage, so we have a long way to go. In Loving versus Virginia, you could say they were just washing out outliers, the court was, and so it wasn't getting that far ahead of the country. The court usually likes to stay 1 or 2 steps ahead of the country, not 10 steps ahead of the country. Here, there would be 10 steps ahead. So all of that is just pure agreement with what you said. On the other hand, you know, it's not as if the court is necessarily going to have the luxury of time, right? So again, going back to the Loving analogy, in 1955, the court had an interracial marriage case that was before it called Name versus Name, and it punted on that case. It was handing out in the wake of Brown all these per curiam orders desegregating, public, parks and public transportation and all that stuff, but it stayed its hand at interracial marriage, said this is too incendiary, we're going to wait. So it got to wait those 12 years between 55 and 67 in order to do interracial marriage. Here we don't have 12 years. Sevic and Nevada, the Abercrombie case in Hawaii, both of those are bubbling up to the Supreme Court. So at most, the court is going to buy itself 2 years if it kicks this can down
and
the
what
road.
You
it
mean
can't kick
is
the can that far down the road.
Right, and that's because the Nevada case and the Abercrombie case are cases in which courts affirmed state-level bans on same-sex marriage.
Exactly.
Right? So it's the opposite, it's the other side of the coin.
And because I'm just a lowly journalist, I tend to see these in terms of personalities. And one of the fascinating aspects of the Perry case is that the lawyers for the plaintiffs in the Prop 8 case are David Boies and Ted Olson, who were the adversaries in Bush v. Gore, and Olson was Solicitor General under Bush, and David is a big Democrat. What's interesting about the two of them is they see the case very differently, and it's Boies who wants to let's just win in California and get the hell out of here, and just win this case, and Ted Olson, the great conservative, is, no, we got to go to the Supreme Court, and I'm going to get Justice Kennedy's vote, and all 50 states are going to be, it's just interesting how he's become sort of messianic about this, where when Boies is like, no, calm down, let's just win and get out of here.
So Kenji, though, even if, I'm taken with your point about Nevada, and even if it's, and Hawaii, even if it's only another year or two, you still would have this kind of basis and a little bit more time.
Right, but here's what you don't have. Yeah, so
state-level
you're right. That year or two, given that the rate of approval for same-sex marriage is not only growing, it's growing in a nonlinear way, it's accelerating. So a year or two may actually make a really big difference. This is the first year that we saw 4 referendums go, in the pro-marriage case.
And there are big plans for many more.
Exactly. But all that said, there's a difference between this case and other cases that doesn't just go to the personalities of Boies and Olson, which are huge. It goes to the fact that there was a trial in the Perry case.
Which was so convincingly won.
A 12-day trial with a 3,000-page transcript. The justices won't necessarily read it, but the clerks will read it. Mm-hmm. That transcript is like a shining civil rights document. You cannot come away from that transcript and not have your views in whichever direction be moved.
And it's now a play.
And now it's a play by Dustin Lynch.
It's actually incredibly well done.
Yeah.
The very well-known playwright
Dustin Lynch Black, who did Harvey Milk,
has basically edited down the transcript of the Prop 8 trial and made it to an evening of theater, and it's riveting and it's smart. And
I actually just had, as Nan knows, a conversation with Lance, and I was saying to him, was it weird for you, because he's also on the board of the American Foundation for Equal Rights, was it weird for you to have sort of Ted Olson take short breaks from this marriage litigation to go argue Citizens United, because these guys are all lefties, right?
Yeah.
So for Ted Olson to be on their side is great, but then he goes off and does these things that they think are like anathema, right? And Lance's response was like, no, we want Ken Mellman, who's also on our board, and we want them to remain conservatives because that's where they're the most effective.
He was proving.
So I hate to end this discussion on that particular note, but we could go on all night. This has been just wonderful. Thank you. Hasn't this not been a treat for everybody? Thank you, Kenji and Emily and Jeff. And thank you all so much for coming.